How you doing, Leah? How you doing, Estella?
Hello, I'm good. How are you?
Doing well.
Good morning, Andrew.
How's everybody?
Doing well. How are you, Judge?
I'm hanging in there. I'm telling you guys right now, so you know up front, you have some pretty stiff competition. My wife is making her world famous dressing as we speak in the house. It's very aromatic. She may come in and ask me to have to sample some, and I may need to do that. So,
Okay. All right. I think that would be a great reason to have a brief recess.
how you doing, Estella? You're muted.
Good morning, Judge. I'm doing good.
It must be a rough day for you because it's well into the afternoon.
Not too bad.
I'm glad to hear that.
Getting ready to do my dinner prep also.
Hello.
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 Hi, Mr. Mulligan.
Are you Katie?
Yes, it is.
How you doing today?
Good. How are you?
Good. More nasty weather.
What you guys got going on down there?
Yeah, we got a little water, rain, spitting snow, and very overcast.
It's overcast, but it's not getting any rain or snow, so we're okay.
Ah.
How you doing, Ashley?
Good, thank you. How are you doing?
I'm hanging in there.
That's good.
Making
you
up
been-
for-
Have you been getting snow up north?
Nothing, just like patches here and there, but nothing. It's not completely covered. It looks good when it comes down. It hits the ground and it melts. So that kind of stuff. Are we expecting anyone else? Mr. Mulligan, are you expecting anyone else?
No, sir. I've got Jay Emery with me,
Okay.
and I've got you on speakerphone.
I understand that. Mr. Adams, are you expecting anyone else?
No, Your Honor.
Okay, read the case, please.
Case today is an interest of the St. Croix tribe versus Elmer Emery. Case number is 20-CV-203. Honorable Stephen Bully is presiding. The Prince Your Honor are for the tribe. Andrew Adams, Ashley Duffy, Leah Jers, and for the defendant, Elmer Emery, and his attorney, Thomas Mulligan.
Your Honor, our new development is that Elmer Emery has filed for bankruptcy, with the bankruptcy number being 1-20-12915, and therefore an automatic stay from the federal bankruptcy court has been issued, preventing any further more activity in this matter.
Your Honor, if I may, could I just ask Attorney Mulligan to repeat that case number?
You bet. 1-20-12915. Christopher Seelen, S-E-E-L-E-N, is the trustee. We've got a 3:41 meeting on December 28th, 2020 at 10:30 a.m. by telephone.
Mr. Adams?
I'm sorry. Yes, Your Honor. Did you?
You have a response to this?
I guess I've got a few questions, if I may, Your Honor. Tom, are you representing Jay in the bankruptcy, or does he have a different attorney?
I'm representing him.
Okay, and I'm assuming you filed in the Western District of Wisconsin?
Correct.
Okay. Do you have a copy of can you transmit to us in the court like a copy of, like the filing certification or the receipt that you got from the Western District?
Yeah, I've got it right here in my hand, and I've got no problem, Adam, giving you copies of what we filed. Do you have an email or a number I can send you for the confirmation that you're requesting?
Yeah, I mean, you can send it to the same, my normal email address that we've been corresponding with, aadams@hoganadams.com.
Penny? Penny's out for lunch. My secretary's out for lunch.
Oh, that's fine. I mean, at your convenience.
Sure.
So, I mean, not to, don't intend to hide the ball or anything like that. But I mean, so I take it, Tom, that you're going to advise Jay not to participate in any type of trial scheduled for next week, correct?
Well, I don't think there can even be a trial by virtue of the fact that there's an automatic stay from the federal court, bankruptcy court. Everything's got to be put on hold pending whatever is happening in the bankruptcy.
Well, I mean, Tom, I take the standpoint that there's nothing in the Federal Bankruptcy Act that precludes the tribe from exercising its jurisdiction over your client from a police power standpoint. And so
No. A stay is a stay. You're stayed from doing anything in it as an individual. The judge is stayed from anything as an individual that he was doing. And to violate that stay, then there's a possibility of opening oneself up in order to show cause why contempt shouldn't be imposed.
Well, Tom, the only way that we violate the stay that's been issued by the judge is if we make some type of attempt to collect a debt against Jay. And what I'm saying is that we recognize the fact that you have filed your federal bankruptcy action, but there is nothing in that code that divests the tribal court of jurisdiction, and the court can issue, the St. Croix Tribal Court can issue a decision even on a limited basis to hold the case in abeyance until the federal court, conducts its bankruptcy proceedings.
You're not entitled to a judgment. You're not entitled to a trial. You automatically have to hold this in abeyance pending whatever occurs in the bankruptcy court.
You can't
Tom, do a judgment. You can't do anything.
Well, Tom, with all due respect, that's your opinion. You're not wearing a black robe, and you don't have a gavel that's been issued to you by as an Article III judge. And that's
but I practiced bankruptcy law for 50 years.
Well, that's your interpretation. But Tom, have you ever looked at it from the standpoint of how the Bankruptcy Act impacts tribal court jurisdiction.
I'll be glad to bring an order for contempt if you want to push it.
I mean, do what
Like
you
that
do.
in bankruptcy.
Tom, do what you feel you have to do, but I'm not going to hide the ball. The tribe will file a motion in the tribal court asking for a default judgment against your client if he doesn't participate in the trial, and then we will hold in abeyance any damages until after the federal bankruptcy court issues its decision. And I can tell you right now, we will not be in violation of any automatic stay, and we will have not violated any provisions of the Federal Bankruptcy Act, because there is no waiver of the tribe's immunity in the bankruptcy code.
I'm going to bring an action then against all of you.
Well,
This has to be held in abeyance.
do what you feel you have to do, because we will have not violated the stay if we hold the case in abeyance.
If you go forward with a trial, you are violating it.
That's your opinion, Tom.
What is your authority?
The authority of what are you talking about? I'm only an attorney.
Are you saying that you can go forward with a trial?
Well, we can't, of course we can't go forward with the trial if your client doesn't show up, but there's nothing in that bankruptcy code that forecloses the court from holding a hearing on Monday.
The hearing is off by virtue of the stay. What authority do you have saying that it's not off?
Because there's no waiver of the tribe's immunity in the federal bankruptcy code, Tom. So
There's a stay with regard to you and the judge as individuals violating an automatic stay in the bankruptcy court.
well, Tom, again, we could debate this all night. That's your opinion, right? So if you feel like I or anyone else have violated an order from a federal judge, then you can take that up with the federal court. And go right ahead, by all means. You're talking about hypotheticals at this point.
No, no.
Yeah, with all due respect, you are, and it's your opinion, Tom.
The federal banking court is the primary court now after the bankruptcy is filed. And the court can rule on it or not rule on it. I would suggest that the tribal court judge stay the proceedings pursuant to the filing of the bankruptcy. If he refuses to do that, then I'll take the next step.
Okay, I've heard what both of you guys said. Mr. Mulligan,
I didn't hear you, sir.
You're telling me something that I don't know. So I want you to brief that to me. Mr. Adams, once you get that brief, you need to respond to me. And I need that all before Monday morning. This is kind of a rough time because it's the day before Thanksgiving, but this is just presented to me now. We do have a trial scheduled for Monday morning. And if I don't have to, I'm not going to put it off.
Well, Your Honor, we, as the court is well aware, we've crossed this bridge recently in the past, and we will essentially be filing the same pleadings that we filed before for the court's convenience. We will do our best to have those filed by the end of the day today with the clerk, and we would ask the court at a minimum to hold true to its scheduling on Monday. And if Mr. Emery, if the defendant does not participate, as we have argued in the past, Your Honor, the court has authority to move forward with a limited default judgment against Mr. Emery for failure to appear. And the court has full authority to hold that in abeyance without any violation of any federal proceeding. And if Attorney Mulligan wants to file a frivolous complaint with the bankruptcy court, that's well within his purview. We have no control over that, Your Honor.
I'll be not filing a frivolous complaint. I'll be filing an order for contempt against you and the court if need be.
However, Mr. Mulligan, I'm still asking you to,
I'm sorry, I didn't hear you, sir.
brief on this.
You broke up, sir.
Yeah, Your Honor, you broke up there for just about 10 seconds.
Okay. Says my internet connection is unstable. So however, I want a brief from Mr. Mulligan on this. Did you get that, Mr. Mulligan?
I understand what you're asking.
All right.
I would like to have the brief of opposing counsel so that I can reply to that in terms of briefing. And we do have a difficulty with regard to the fact that this is a holiday, and I see no problem or reason why the trial date cannot be struck until the participants have an adequate time to present whatever Your Honor is requesting.
Your Honor, if I may, the defendant and his counsel created this situation concerning the timing. Okay, so from our perspective, in a normal situation, if Mr. Mulligan is asking for the court to either reschedule or do something, the burden should fall on him to file some type of motion with the court. And then for the tribe who did not create this situation, then to reply to it.
He has the right to file for bankruptcy, and that in and of itself has a stay against any further proceedings.
Mr. Mulligan,
Yes, sir.
you're putting new information to the court. Not presume that this court understands that whole thing, and that's why I'm asking for a brief. You're telling me something that I don't really have a whole lot of background on. I do not have 50 years of experience, and I'm not a trained attorney. So you're gonna need to brief that to me, and you need to do that as soon as you can.
Which means how much time do I have?
Friday afternoon.
Friday afternoon.
Katie, how late are you working on Friday?
Well, Your Honor, it's technically our vacation.
Oh, you already have, so you're already off. Katie, can you take this and receive this on Friday and get it to me?
Yes.
Okay, Mr. Mulligan, you have until 1 o'clock on Friday.
That is your order, Your Honor.
It's my order. Again, understand that you're talking to someone who does not have a background in bankruptcy, does not know this stuff, so you're gonna need to be kind of precise. And if you're gonna make reference to specific bankruptcy laws, if you could provide me with copies of that also, I'd appreciate it.
I understand your order.
Thank you. All right. I have not postponed the trial, and I'll make that decision after I get the information from the parties. Okay. Mr. Adams, you indicated that we've been down this path before, and yes, we have, but this is a different case and a different attorney, so we have a different response. And so I'm going to wait till I hear his response. You You can either file what you have filed previously, and we can go from there. Or you can wait until you get Mr. Mulligan's documents, and then you can build off of that and respond from that if you wish.
So, Your Honor, when would you like us to respond to Mr. Attorney Mulligan's filing? Do you want that Friday, or when would you like it?
Would you be able to do it on Friday?
Well, Your Honor, if we're going to do it on Friday, I would ask that Attorney Mulligan have until noon on Friday, and we have until 5 o'clock on Friday to file something with the court.
All right, let's do that. Okay, Mr. Mulligan, you've been back to noon. You have until noon to file, and then the tribe has until 5 o'clock to respond. And I will try my best to respond by before the day's over. Our Saturday.
I'm not consenting to jurisdiction in this matter.
Well, so if you're not consenting to jurisdiction, Attorney Mulligan, then why would you participate in some briefing?
I have been ordered by the court. I'm not consenting to jurisdiction because I believe that the automatic stay even precludes any further activity until the bankruptcy court decides the case in the federal system.
Okay, you've heard what I have to say about this. You guys have a schedule to keep. Expect to hear from me in a timely manner. This hearing's adjourned. We'll talk to you later. You guys have a good Thanksgiving.
Thank you, Your Honor.
Thank you.